Anyone that has their cell phone turned on, could you please silence it or put it on airplane mode or put it back in your car? The public hearing before the Sawyer County Board of Appeals is hereby called to order. It's 5 p.m. at Sawyer County Courthouse in Hayward. On behalf of the board, Al Gerber, Laura Rusk, Steve Kelsey, Gordon Christian, Joe Barron, also attending Jenny Chabek, and I don't see Jim Bassett. Okay. From the zoning office, Jay Kozlowski, Kathy Marks, and Casey Misevitz. Okay, thank you. And representing the board for legal counsel, T.J. Juffy. Those persons desiring to give pertinent testimony will be afforded to do so. As recognized by the chairman, that person will clearly state their full name before giving testimony. Each hearing will follow this order: reading of the application, submission of the file to the board, applicant statements and presentation of evidence, testimony of those in support of the application, statements from persons in objection to the application, rebuttal as permitted by the board, and decision by the board. Orderly procedure requires that each side shall proceed without interruption by the other. All testimony will be addressed to the board, and there will be no questions or arguments between individuals. Any persons aggrieved by a decision of the board may appeal the decision to the circuit court within 30 days of the date following the board's decision letter. The day following the signing of the board's decision letter is the first day of the 30-day appeal filing period. This public hearing has been published as a Class 2 notice in accordance with Chapter 985 Wisconsin statutes and Sawyer County Record and the Sawyer County Gazette on March 11th and March 18th, 2026. The public hearing will follow this order: approval of the minutes, variance applications, new business, and adjournment. I failed to mention that today's date is March 24th, 2026. Okay. Kathy, did you have some?
Yes, I do. I'd like to do some introductions here tonight. We have Alan Gerber as chairman, Laura Rusk as vice chair, Steve Kelsey as member, Joe Barron as full member, Gordy Christians as alternate. Sitting in and who is going to be a new full member will be Jenny Chabek. And we also have one member that did not show up, and that is James Bassett. He had a previous appointment. Thank you.
Okay. Did everyone receive a copy of the December 6th, 2025 minutes? Okay, any discussion or changes or corrections to that? Hearing none, is there a motion to approve those? Okay, is there a second to that? Second. Motion to approve and seconded. All in favor, saying aye. All right.
May I
Yes.
say one thing? Please turn your microphones on when you talk, because otherwise if I have to go back and hear something, I am unable to. Thank you.
All right. I may need a little coaching on this next part. Do we need a motion to determine that this is the correct jurisdiction?
Unless someone's questioning it, but I don't think no one's questioning.
Does anyone in the audience feel that this is the correct? Yes, sir. Please step forward and state your name.
Good afternoon or evening, or whatever we classify 5 o'clock as now. Anders Hellquist, the attorney for Larry and Tammy Johnson, and we're objecting to the jurisdiction that the board has on this because it's our position that the Hallbergs are not persons aggrieved or aggrieved persons that entitle them to an appeal before this board of Mr. Kozlowski's decision. I have a handout that I can provide to the board if you'd entertain that.
Yes, sir. We will. You won't get them back, but I assume you don't want them back.
I made plenty of copies.
Okay, thank you.
Can you provide one of the Hallbergs? Provide one of the Hallbergs? Yes.
Mr. Gerber?
Oh, more. Yeah, come up late.
A lot of information here we probably could have had before review.
Okay.
Just a second, sir. At the beginning of your opening statement, you said something about 5 o'clock, but I didn't catch.
I just said good afternoon or good evening, depending on what we
Okay,
classify
all right.
5 o'clock as. With the lengthy sunshine, I'm going to say
Thank
it's
you.
still
All right.
afternoon.
And it's cocktail hour.
So, thank you. May I proceed?
Sure, fire
Okay.
away.
You have two documents in front of you, a lengthier position statement that provides a little bit more detail on the Johnson's position here, and then a second document that we've proposed called the decision worksheet that helps you kind of work through this initial jurisdictional issue. It's a suggestion, and obviously we defer to your counsel on how to work through this, but we thought it might be an easy kind of checklist to go through as you're considering whether the Hallbergs have standing to appeal. So under first, again, to appeal Mr. Kozlowski's decision, the Hallbergs have to be aggrieved persons, both under state law, under 59.694, and under the county zoning code. Under the county zoning code and under your bylaws, an aggrieved person is defined as someone whose substantial interests are adversely affected by a determination. I looked high and low through the Hallbergs' application, and they don't identify any substantial interest of theirs in appealing a decision regarding my client's property. And they don't identify anywhere how they're adversely impacted, how those substantial interests are adversely impacted. Basically, what's their injury? They don't list one. They're required to provide that in the application so you know whether you even have jurisdiction, and they haven't done that. We don't think they meet the definition of an aggrieved person under the Sawyer County zoning code, and therefore we request that you dismiss the appeal at this early jurisdictional stage. Looking at how the state, different cases have interpreted aggrieved person, the Hallbergs don't meet that standard either. They need to have two things to be aggrieved. They need to have an injury in fact, that's number one. And number two, they need to have a legal interest that the law protects or seeks to protect or regulate or protect. Again, they do not have an injury in fact. They haven't alleged any injury. They haven't claimed any injury. They haven't been able to come up with anything, probably because there is no injury. Injuries just can't be hypothetical or conjectural or speculative. The case law says it needs to be direct. It needs to be a real and immediate threat of direct injury. And again, that is not in the record before this board. They had an opportunity to do that with their application, and they did not do that. There is just, again, no injury in fact. So again, when you're going through the rubric, do they have an injury in fact? You would check no. And answering no to any one of these questions in the decision worksheet means you don't have jurisdiction because the Hallbergs aren't aggrieved. Additionally, they don't have an interest which the law seeks to protect. That injury is not, if they had an injury, again, they don't claim one, it's not to an interest that the law seeks to recognize, regulate, or protect. Let's remember how this appeal started here. It's when the Hallbergs emailed Mr. Kozlowski reaching out for an opinion about my client's property. The Hallbergs then used that email from the zoning administrator to appeal the decision related to my client's property, not the Hallbergs' property. And they're doing that in an attempt to undo a 28-year-old land use permit. There is no legal interest that's been identified by the Hallbergs where they've shown a right to appeal that administrative decision on someone else's property that the property owner didn't initiate. So we request that the board dismiss this appeal right at the beginning for lack of jurisdiction. We request you go through this decision worksheet, answer the questions one by one, and the answer to no to any one of these questions should result in a lack of standing on the Hallbergs' part, a lack of jurisdiction by this board, and quite frankly, an early evening where we all get to go home and we put this one to bed. So thank you. If you have any questions, I'll take my seat.
Not at this point, but we may later.
Thank you.
Mr. Chair, this is Attorney Malia Malone. The zoning administrator shares the stated concern about standing regarding whether or not the appellants have alleged any injury. We also have a handout, but I'll hold off on asking Jay to pass that around to the board members, but we do join Attorney Helquist's arguments as they relate to standing.
Thank you. Okay. Okay, is there anyone, are the Hallbergs here or anyone to speak on their behalf? Step forward to the mic, please identify yourself.
My name is Aaron Hallberg. I am one of the appellants for this case, and we do own the neighboring property, 210339. We didn't know this was coming, but I guess you want to hear some of our side of the story about this cause for standing. The petition for variance notice that kind of got this ball rolling goes back to October 22nd, 2025, when we were made aware from the Surrey County Zoning on their letterhead that a public hearing was to take place November 18th, 2025 at 5 p.m. We were given this notice, and it said, "This notice is being sent to you as a neighboring landowner to the property described above." That's our interest. That's our interest in this case. We're a neighboring landowner. And I don't know that anybody would contest that we had the right or the ability to show up at that hearing in November and speak either for or against that petition for variance. I would contend we had that standing. But this appeal tonight is about something that happened later in October, and the zoning administrator, I guess it was 5 days later on October 27th, issued another notice, and it said that this case is withdrawn for November and will be modified and heard at the December 16th, 2025 Board of Appeals meeting. You'll be receiving updated paperwork notification at the end of November for the December hearing, which we did. On November 24th, we received another notification from Surrey County Zoning with a revised petition for variance that was quite a bit different than the one that was issued in October. And that's the nature of our appeal. And I would just simply contend that although I don't have the legal degree, what we're here to talk about tonight is the difference between the petition for variance that was drafted and proposed to come to this committee in October, and then without any action from this board, that was withdrawn by the zoning administrator. So any standing that I have to speak up about this appeal of the zoning administrator, I think, can just simply be summarized by saying our chance to speak up for that change between the original petition for variance and the revised one has not happened yet. And that's what we're here tonight to ask for. I don't know how this goes as far as your actions on this cause for standing, but I guess I would like to reserve my rights to consult additionally with legal counsel if need be to support our cause, because we haven't had any notification that this was coming. And if there's any questions, I can try to answer those now.
I don't hear any right now, but we maybe call you later if that'd be okay.
Sure.
Thank you. Anyone else to speak on behalf of the appellants? Anyone else to speak on behalf of the application? Okay, hearing none. Anyone to speak against the application?
So are you just looking for still determination of jurisdiction at this point? Okay, thank you.
Thank you, Mr. Chairman. You heard 0 injury alleged by the Hallbergs. They couldn't come up with any injury. They don't have jurisdiction. Their only interest that they said is they are neighbors. Being a neighbor isn't an interest that's legally protected here. The Jelensky case, says just being a neighbor isn't enough. To have standing, you need more. You need actual encroachments or other damage to have an injury. So respectfully, we request dismissal for lack of jurisdiction because the Hallbergs are not persons aggrieved.
Okay, stay there for a second. When I read the statement at every meeting, it says any person aggrieved. It doesn't say injured. And I don't know if that's a defining moment there or a phrase or a word or a statement. So I'm going to ask you your opinion of injured versus aggrieved. I'm going to ask our corporate counsel the same question. I'm going to ask the zoning administrator the same question. So since you're at the microphone, we'll start with you.
Sure. So let's just, if we work through the worksheet, that kind of helps determine and define what aggrieved actually means, that decision worksheet. So under your bylaws defined aggrieved as a person that has a substantial, let me just, a person whose substantial interests are adversely affected by a determination. Substantial interests, not just an interest, not, hey, I'm just a neighbor, not, I'm interested in this case, but substantial. Additionally, that substantial interest needs to be adversely affected by a determination. So that strongly implies some type of injury. If you're adversely affected, you've been harmed some way, and they haven't identified any harm that they've suffered. And then you turn the page. And so again, under the BoA's definition, we propose that the answer to both of those questions is no. Turn the page, and how does the state law define the standard for a person aggrieved? It's identified through the case law that we cited in the position statement. But I'm going to do a solid and not reread a brief to you guys.
Thank you.
Yep. Yeah, lawyers have a reputation. I'm trying not to uphold it as being too lengthy. So question 1, have the Hallbergs in their appeal application to the BoA claimed or identified any injury in fact? And the case law says to be aggrieved, Wisconsin Supreme Court says to be aggrieved and have standing, you need an injury in fact, and it needs to be an injury which the law regulates or seeks to protect. So that's where we say, have they suffered from the zoning administrator's decision? Have they suffered an injury related to the property that the Hallbergs do not own? That injury, under the case law, must be sufficient, concrete, not hypothetical or speculative, and it must be real a real and immediate threat of direct injury to the Hallbergs. We don't have that in the record. We've got nothing from the Hallbergs on that. The answer to that question should be respectfully, no. Number two, if the Hallbergs have identified an injury, which they didn't, is that claimed injury to an interest which the law recognizes or seeks to regulate or protect? That is, have the Hallbergs in their appeal application to the board, or even tonight, claimed or identified any interest with which the law seeks to protect when they've challenged the zoning administrator's decision related to property that the Hallbergs do not own? They said, again, nothing was provided in the application. They said on the record tonight that their interest is they're the neighbor. If a neighbor is a sufficient interest to bring appeals to the board without an injury, and just because you're a neighbor, then Katie, bar the door. There's going to be a flood of appeals coming in if that's the standard with that incredibly low bar. So, we don't think there's any interests that protect, or that the law seeks to protect. Again, I don't think we even get to that question because the Hallbergs haven't even alleged an injury. Does that kind of answer the question, how I distinguish?
Your version of it, yes.
Yes.
Thank you. All right. Corporate counsel,
Well, I don't think I can counter what your bylaws say and what the case law says. I mean, and understand that in this kind of a case, you guys are the judge. You listen to both sides, you listen to what the law is. Anyone can interpret the law, and judges do it all the time, and you're the judge. And in this case, you listen to the arguments made by counsel. And it's not necessarily for me to tell you what to do, and that'd be improper for me to do that. But I mean, the law on what it takes to have jurisdiction has just been provided. Okay? And Hallberg's get a chance to counter that again and say what they want to say. But that's what the law is. And how you interpret it is up to you. And I think you have to apply the law. You can't just disregard the law. But I'm not here to tell you what to do. And I don't want to get in trouble for doing that because that's not my job.
all right. I'm going to ask Mr. Kozlowski to give us his interpretation of whether this is the correct venue.
Thank you.
Thank you. Jay Kozlowski, Sawyer County Zoning and Conservation Administrator. Specifically, when looking at ordinances in general, and as to, does it meet the merits of the jurisdictional claim, I specifically would look at your bylaws. And Section 14 has definitions of what an aggrieved person is. Any person whose substantial interests are adversely affected by a determination. I have not heard what the Hallbergs' substantial interests that are adversely affected by my determination have been. It's that plain and simple to me. I am prepared to further go into why I based my decision on this case, but I think we do need to get past the jurisdictional aspects first. Thank you.
All right, thanks.
And again, the definition is on your first sheet that he provided you, of what the BoA document says.
So if I'm reading all of this correctly, these last three testimonies, right now we're deciding whether or not we're the right board to hear the appeal from the Hallbergs.
No, that's not necessarily true. It's whether he has jurisdiction to bring this action. You are the right board to hear it. It's whether he has jurisdiction to bring it. And one of the things that what I will say, because it's not, is that when zoning sends out notice to the people within 300 feet, 500, those are interested people because they're close to the property that's being rezoned, get a variance. And they send that out so that those people have notice and they're interested and they can come and give their opinions to you guys before you make your decision. Being interested does not make you harmed necessarily, it makes you interested. So just the fact that you get notice and you show up doesn't necessarily make you harmed. You can, I mean, some people that, you know, if there's a decision that affects someone to the point where there's substantial interest that's adversely affected, then obviously there's a harm there. But I want to make sure that you don't confuse notice and interested parties with someone that's aggrieved.
TJ, okay, here's just my initial reaction to it. The Hallbergs obviously were not aware that this was going to be the course this was taking, and nor were any of us until we got here this evening. So are we within our jurisdiction or rights to ask the Hallbergs why they feel they are an aggrieved?
For sure, you did
Okay.
once already, you can do it again.
Okay.
Yeah.
So before any decisions are made on whether or not we decide we have the jurisdiction to hear it, shouldn't we hear from the Hallbergs as to why they feel they are an aggrieved party?
Right, and it was asked once, and I think it'll be asked again, because counsel for the Johnsons got to go up again and talk about his presentation. But sure, I mean, I think you can go back and forth between the two parties, because that's what a judge would do, and you're the judge. And if you want more information, you keep asking the parties to provide you with more information till you're satisfied that you can make a decision.
We did, of course, have all of the other information prior to the meeting tonight, the correspondence between Jay and the Hallbergs, detailed correspondence. And was it ever told to them when they filed this that perhaps we didn't have jurisdiction to listen to this?
Well, but to understand this is that when someone files, whether it's in court or in front of you, I mean, it's not the Johnson's attorney's job, it's not Jay's job, it's not my job, it's not your job to tell someone how to do it and to do it properly. Just if you file in circuit court, can you file on your own? Yes, you can. Is there some potential danger in filing on your own that it might get dismissed by the judge because you didn't do it right? Or you don't have jurisdiction? Yeah. And when you go into court or in front of you guys, and I'm not saying how this is gonna turn out, but it sometimes doesn't make sense for opposing counsel to tell the other side that I gotcha, or I've got something that you don't know, or I've got something, I'm not gonna give it to you beforehand.
All right, I mean, I know this
And that's
isn't
kinda what's
Perry
happening.
Mason.
That's what's
I
happened here,
understand
yeah.
that, but it's just, and I'm not saying I'm with the Hallbergs either.
No.
I'm just trying to get it right in my head, since they didn't know that this could not be our jurisdiction, that it's important to afford them the opportunity to present their case that they are an aggrieved party.
But it is in your bylaws, which are available in the public, and when you file the kind of action that they filed against the decision of the zoning administrator, procedures are in the bylaws, and what you have to prove and show is in there, okay? So, and I'm not saying, you might have a good case against Jay, you may not, but to get there, this body has to have jurisdiction. So you gotta be pursuant to that section of your bylaws, you've gotta be, have a person whose substantial interests are adversely affected by determination. And I think that's how
I
you
mean,
get
and I guess
jurisdiction.
now that part is clear in my mind, and this isn't that, in my mind at this point, if it's against Jay or against the Hallbergs,
right.
it's just trying to understand what,
Jurisdiction is first, and then the body of
Okay.
what the appeal
Okay.
was is second.
all right.
I have a question for Jay or possibly Al. When appeals have been done with this board, when appeals have been done to the board in the past, are the appeals generally coming from the people that initiated the variance to begin with?
I'll turn that off, or one of them. My recall isn't that specific, Joe. I guess, no, I don't guess. I don't know that it's only from people that have filed for an appeal. Primarily it is. They were turned down or altered and took it to a higher authority. So I can't answer your question. Maybe Jay can.
I've been doing this longer than Jay.
Okay.
Not obviously his job, but my
Right.
job. And what I will say is that typically, when the zoning administrator's decisions are appealed, it's by someone that's affected by that decision. And, or like I said, if there's an appeal, and this is what happens, an appeal of his decision. So usually it's a person that's adversely affected. You can't do this. Like, well, I don't believe that. I'm going to appeal your decision to the board.
Right.
That's typically what happens in these kind of situations.
And it's generally the person that initiated the variance, I would think.
Well, not necessarily,
No?
but,
Okay.
but it usually, sometimes it's not a variance. It could be a rezone. It could be
Right.
any decision he makes or what zoning department makes.
Has this board ever been asked to determine if something has been aggrieved?
Well, so jurisdiction you're talking about.
Right, jurisdiction.
Yeah, so, if you look at the procedure in
Yep.
the bylaws, the first thing we'll ask is there a question about jurisdiction?
Yep.
And if neither side, if it was Jay's being appealed or the other side, object to this body having jurisdiction, we move to the next step. If there is an objection, then we go there. Now, I haven't been sitting on this, assisting this board for that long. But this is the first time I've sat on one of these where there's been a question as to whether this board has jurisdiction and whether the appellant's been aggrieved. That I can recall.
I've been here a long time, Al's been here a long time, this whole thing, I can't tell you how many times I have read and reread and trying to get it straight and understand what's what. No, we've never heard anything
No,
like this.
we're plowing new ground here. Jay, did you have a comment?
Yeah, so there's two specific types of appeals requests that you would hear. One would be the zoning committee appeals. And generally, any zoning committee appeal, it would have been that property owner who was denied at zoning committee, whether it be for a rezone or a conditional use permit, that has appealed their request to this board. And they would be an aggrieved person because it's directly affecting their property. The only other one that I can potentially think of, which was specifically as a zoning administrator appeal, where I believe it was potentially brought up but then quickly dismissed, was for the Kurzweil case, where there again was an adjacent property owner to Kurzweil in which he had demonstrated, at least to this board at that time, that he was an aggrieved party to that case. But otherwise, I mean, I'm asked to make a determination on a weekly basis, if not sometimes a daily basis. And anyone that's asking for a determination is generally reflected on their individual property, not an adjacent property.
If we, as a board, determine they aren't aggrieved, is that then automatically no jurisdiction?
Right. By the definition, you're gonna let them speak again.
Right.
And I think they're hearing what they might have to do to become aggrieved, and they can make an argument about that. And so we're not done yet, but
No.
if you determine that, yes, you gotta have jurisdiction, and if they're not aggrieved in your mind, then it ends without getting to the body of the appeal.
Okay.
I don't know if I'm reading too much into this or if I'm not reading enough into it, but I thought the Hallbergs appealed the decision that allowed for expansion on what was originally called a two residential lot, or a lot for two residences. I didn't think that they were appealing for personal harm or being personally aggrieved. I thought that they were appealing because the letter of the law or the interpretation of that law was not being properly administered.
But to do that, per our ordinance and per statute, you have to be aggrieved in some manner or fashion that satisfies you guys.
Okay, I think we may be splitting hairs here, but anytime an ordinance isn't properly administered, isn't
But in this-
everybody aggrieved?
But this isn't an ordinance, it was a decision that Jay made, and they didn't agree with that
Okay,
decision.
I won't
so-
say ordinance, then I'll say
Right.
a decision.
Yep, yeah, so,
Okay, so-
and I don't think you're done yet. I think that Hallbergs want to speak again, and the other side may want to speak again. I think you don't have all your information yet to make a decision. So I don't think you're sitting here waiting for a decision, because Hallbergs have spoken once, they've spoken twice. I think Hallbergs want to speak again.
Yeah.
And I think once you get all that information, then we can do more of this discussion and make your decision. Would be my proposal.
All right, good enough. Does the board have any other comments or questions, or, okay. Would the Hallbergs like to speak again? We got a new player, so we're gonna need an identification. We have a new player, so we need identification.
My name is Sarah Hallberg. I live at 10335 N Duffy Road.
Thank you.
Bringing the
All right.
thunder now.
Yeah.
I just have to say, this is interesting from a civic standpoint. I'm learning, maybe you're learning. So the attorney is right. We didn't state any aggrievement or injury on the application, but I'm looking at the application from the zoning department, an appeal of decision made by the Surrey County zoning administrator. We were asked for some personal information, the property at stake, the present use of the property, decision of the zoning administrator that we were appealing. And then it is my opinion that the zoning administrator did or did not keep within its jurisdiction when making its decision. Justify your opinion, which I tried to do. It is my opinion that the zoning administrator did or did not proceed on the correct theory of law when making its decision. Again, justify your opinion, which I attempted to do. It is my opinion that the zoning administrator's decision was or was not arbitrary, oppressive, or unreasonable and represented its will, not its judgment. Justify your opinion. And finally, it is my opinion that the evidence was such that the zoning administrator could or could not have reasonably made the decision in question. Justify your opinion. Nowhere on this form does it ask me what my injury was, what my aggrievement was. I think it's pretty interesting that we're talking about this, and I'm not saying it's not a valid point, but I'm just saying to say that we didn't provide one when none was asked for kind of puts us in a bad light, as if we didn't complete our assignment. I think we are aggrieved by the decision, and as I was hoping maybe not to get into this, to keep it maybe more about what the administrator and we had talked about, because I do think, Mr. Chairman, that you brought up a good point. I think any citizen of the county who sees what's being done and may have a disagreement about it ought to have a voice about that. Somebody that sees some injustice being done should be able to stand up for that sake alone. And I think there is that aspect of this case. The Johnsons were not reluctant to bring up in the past hearing in December that we had an interest in this property when it was for sale. And that's true. We were very interested in the property. It adjoins ours. It would have made a nice addition to our property. We share a driveway easement with the Johnsons now, and with Nelson's before that, the Petersons before that. It's a unique spot because that peninsula, the property really necks down to a narrow portion before you get out to where the house and the office are. So what's interesting, I guess, about the real estate part is you can say, well, that's not within the jurisdiction of this board, and you're right. But we had talked to realtors and our own, and we knew other people that were interested in the property as well. And our reason for maybe not offering a better, making a better offer on the property earlier than the Johnsons was because of what the realtors were telling us could and couldn't be done with that property. And I believe they were giving us good advice. But the zoning administrator's decision last fall changed that after the Johnsons had already bought the property. So to say that that property with one small dwelling, 537 square feet, and 864 square foot office could have been modified in such a way that that two dwellings could have been present on that property, that would have changed our opinion about what type of an offer we would have made on that. I think we were kind of looking at the purchase as what can be done on this property, try to make a valid assessment of the market value based on that. Whether we actually intended to develop two houses over there or not, I think is irrelevant. We were trying to make a fair offer based on how we thought the zoning laws applied to that property. So that's our main agreement, I think. And I did say two houses because it's interesting that when this appeal went to the Town of Hayward Planning Commission, the Johnsons were being informed and the zoning administrator was advising in his recommendation report to the Planning Commission that the Johnsons could wreck and rebuild both the office and the dwelling as two-story buildings within the existing footprint with no variance required. And that was what the Planning Commission considered as the default position of zoning department when they acted on that. And really, if you remember, what they were asking for at that time was an expansion of that footprint by 208 square feet. They wanted to make the 864 square feet, 208 square feet larger. That was denied at your December meeting. But really, in this back and forth dialogue that we had with Jay, which I really appreciated, Jay was very good at communicating with us and answering our questions. We were learning a lot. But at one point, he realized that, oh, I was wrong about that. I was wrong that both of those buildings could be wrecked and rebuilt as two-story structures. There was a limitation that he found that limited the amount of square footage that could be increased to 50%. So really, the story changed, and that variance still kept going through the process. And I think he would agree, it got more accurate as it went through the process. But I say all that just to say that this has kind of been like a moving target ever since that October announcement came out. We have an interest in the property. We were potential buyers, trying to value the property as if it was usable in a certain way, which we understood, and then that way got changed, which we disagree with. It would, as currently it sits now, what the zoning administrator has determined, it would add additional occupiable dwelling space within the non-conforming area of that lot significantly, like up to over three times the amount of area that's there now. 537 square foot cabin, they could basically rebuild that 864 square foot office as a two-story dwelling. That gets you up over to 1,700 square feet from 537 that they have now. That's increased pressure on the lake in a non-conforming area. It's additional traffic on our shared driveway. And I don't really know the Johnsons that well. I don't know how they plan to use it, and they don't have to tell us that. But this is not their home. This is not their main property. So, I mean, we do wonder, like if they built a two-story, 1,700 square foot home, 25 feet off of Lake Hayward, would that be a prime secondary vacation rental home? I would think so. They haven't told me that they're going to do that, but I think I have an interest in trying to stand up for what's right, because once they build that larger home within the non-conforming area, we've kind of lost our ability to say something. So that's what we're trying to speak up for here tonight. Anything else?
Yeah, just to reiterate that, as we didn't actually have a realtor. We did have a fair market value assessment on the property several years ago when we first learned that Larry Johnson was interested in selling it. And Larry Nelson, the previous owner. And so he said, you know, it's a unique property, but there's a lot of limitations, including one 537 square foot dwelling in that peninsula. And he and everybody else, and I'm going to guess the people who bought the property thought there was one dwelling. And when we found out that there was two structures being called primary, we were shocked. So that determination changed a lot, and we do feel aggrieved and, not physically injured, but it affects us.
Take your time.
Okay. The other thing I just want to point out is that it's very rare, everyone's confused by this case, why there would be two primary structures on a lot. It is residential. It is, the office would have been a secondary structure to the main purpose of the property because it is a residential property, and it was always used that way. This was going to come up later for the appeal part, but again, to point it out, there's no plumbing in the building. It was a garage converted to an office. So we felt no threat of that being called a primary structure until after the first variance request was pulled and then re-put out there. And then we realized we were shocked. So I think that's what I wanted to share.
Could I say one more thing? We bought our property in 1999 and had a nice home on it, and we started to raise a family there. And we decided that we were outgrowing that home. And we took the bold step of having that home relocated to Riverside Road, about 1.5 miles away, and lived there while a new house was being constructed, 75 feet back from the water on our property. Our property is, as Ms. Johnson pointed out, a little bit smaller acreage-wise than their property, but we were able to comply with all of the requirements for zoning when we built that new house. And I guess I just wanted to say that because this feels a little bit like a double standard, to say that they might be able to expand a residential area within the neighboring lot so close to the water. And I know our neighbor on the other side, she lives in Massachusetts, but on the Skinner property, she was denied a variance to put on a 200 square foot deck on her building, which wouldn't even add roofed area, but she was denied that because she was in the non-conforming area with her house. So I feel like there's plenty of reasons to grant us standing. I don't know if this is really a jurisdictional issue as much as it is, do we have standing to bring this appeal? But I would just ask you to consider common sense in this situation. And again, going back to the fact that we weren't asked to provide injury or aggrievement in our application. And if that original variance in October would have been brought to this Board of Appeals at the November meeting, we certainly would have brought some of these points for your consideration. And we weren't given that opportunity. Thank you.
Thank you.
See if they have any response. No, Rachel, that's already in the.
Probably state your name again, sir.
Anders Hellquist. So the main aggrievement that they have is they thought the law allowed something or didn't allow something different when they were looking to buy this property in the past. That's a past-looking aggrievement that has no relevance to Jay's decision now. When they don't own the property, they're not looking to buy the property. They have no interest in the Johnson property other than it's kind of a case of non-buyer's remorse. I mean, sour grapes is not being aggrieved. It's not an interest that the law seeks to protect. And any speculation about what a house might look like in the future or whether people might use a legally established easement, again, that's not an injury, it's not an adversely affected interest, and it's so speculative that it's nothing concrete that shows that they're actually aggrieved now. So this backward looking, we wish we would have known because then we would have bought the property. That does nothing for them now in how they're aggrieved since they don't own the property. Let's just put it this way. Just imagine each of you, you're on your home. And I call up Jay and I say, there's something I don't like about your property. I want to change something about your property. And I email with Jay, and Jay says yes or no, one way or the other. It's a decision I don't like. And then I can file an appeal to the board and say, I don't like Jay's decision. I come up to Sawyer County, I recreate here. I have an interest and I should have a voice and I should be able to appeal a decision related to the chairman's property because I emailed Jay about it. That's not right. I would expect you to toss me out this room really quickly and say, you don't have jurisdiction. And that's what we're kind of dealing with here. So standing is a jurisdictional issue. We'd request you dismiss this for lack of jurisdiction because the Hallbergs are not aggrieved persons. Thank you.
One moment, please. One moment, please. The gal on the video, you had said you would chime in later. Is now an appropriate time, or you want to hold that off?
Certainly I can chime in now on the jurisdictional issue. Because jurisdiction really is a question of whether or not the ultimate merits of the appeal can be heard by this board. Because I feel for the appellant, they, wish they would have purchased the property had they known that there was perhaps some more expansive land use rights and structural rights that they could have had. And that's a reasonable feeling. But the other information that the appellant provided was, again, as Mr. Hellquist stated, speculative. They're concerned that there might be at some point in the future increased traffic on a legal easement, concerned about general, the entire community should have a right if they believe that there's been some permit issued or some decision by a zoning administrator that was contrary to the rules and regulations. And the case law is very clear that neither of those are sufficient to grant standing. Just so the board is aware, and I believe Attorney Duffy would advise you that if, for example, this board took up the merits of the appeal and said, well, we know that they haven't alleged any substantial interest that was adversely protected, but we still want to hear this case. That would be subject to appeal to the circuit court. And then the circuit court would be evaluating the same standing issues that Mr. Hellquist and I have outlined. And it would be my opinion that the circuit court would likely find, now, of course, we can't speak for any particular judges, but based upon the nature of the appeal, the information in the appeal, and all of the statements that the appellants have made tonight, I cannot imagine where a circuit court would find that the appellants have established standing. So I would highly urge the board to determine that, although unfortunate, this board does not have jurisdiction because the appellant alleged no substantial interest that was adversely affected by Jay's determination.
Thank you. Yes.
I do have one little correction, that we would be willing to buy the property. He mentioned that we were not interested in buying the property. I don't believe that's an option, but we would be willing to buy it. And a lot of the stuff was speculative, fine, but it wouldn't be speculative to say that there would be a larger structure within probably 26 feet from the water. So that part is not speculative. That is what they're trying to do.
Yeah, and we respect your right to determine what's substantial here. But I think my wife and I both feel that we are aggrieved by what's being so far allowed to stand as administrative decision that could affect our neighboring property. We feel that has an impact on our viewing sight lines of the lake because they are so close to the water. That has an impact on us. The increased pressure on that lot in terms of the additional square footage that we talked about. You can say that sour grapes about not getting the property, but that's not. That's just us looking at having changes going on our neighbor property and what impact that has on our property. Assuming Johnsons stay there for the rest of their lives, I would maintain that we have an interest in that, and it's up to you, I guess, to decide whether that's substantial enough to hear the case and hear the appeal. The gal that spoke that said that if you do hear it and it could be appealed, maybe that's what should happen. I don't know, but I do feel that there are significant enough questions about the actual merits of the appeal that those on the other side are trying to keep it from even being heard. Thank you.
I have a question.
Sure.
When you folks were looking at possibly buying it and you had some realtors help you with potential decisions, at that point in time, because it's a unique situation, did you get a legal opinion from an attorney, or did you guys go and talk to Jay at that point to see what could be done? Because those would be critical questions.
Well, the realtor advised, we did not talk to an attorney. In my mind, it didn't matter. We wanted to protect our property. So what the realtor said, if you want to do something, you should follow up with zoning to try to, because you're a local, you could probably, talk to him, make sure that you can do what you want with the property. Our goal was to protect our property, yes.
Yeah, and I think that we were talking with the realtor that was very experienced in Sawyer County and especially the Lake Hayward area. He gave us a market assessment with several lakeshore properties that he compared to this property. And as my wife said earlier, even the former owner was pretty candid about what could and couldn't be done. And looking at the merits of the case and what the zoning administrator decided last fall, I think that was still accurate. So did we talk to a lawyer? No, I guess we didn't. We didn't feel it was necessary.
And just one more thing to say about that whole situation. We consulted with the realtor, but we did not have a realtor because we ended up with a written agreement with the previous owner that we would be able to have. Now, this is where we fell because we had the confusing language of right of first refusal or first right to buy. So we had a written agreement, and unbeknownst to us, it had expired. It was only good for, well, it expired. So we thought we had more ability to purchase the property than we did in the last minute. So just to clarify some of the stuff from the past, yeah.
Thank you.
Can we ask Jay questions?
Anders, do you want to any response or?
They went first, so every time they go, we get to go.
It's going to get shorter and shorter eventually.
Anders Hellquist, I didn't hear anything other than speculative ways that they might be hurt in the future. There's nothing more at this point. We request you dismiss. Thank you.
Thank you.
Hal?
Board, we'll still have more testimony if we think we need it, but I'd like to poll us to see whether you think we need more testimony or whether you think we're ready to make a decision based on what we've heard so far.
Can we ask Jay a question? Are we allowed to ask Jay a question? Can you refresh memory on what was the difference from the initial variance application to why it was withdrawn and why a second application was put through?
Yeah, and that does go into the aspects of the administrative appeal. So when the original variance application was produced, it initially started with a request to basically convert the existing office building into a habitable dwelling. During that time, during that process, the land use permit document number 98-165 was further viewed, in which basically rendered a different determination by myself in that it was originally permitted as an other primary structure, and the aspects of needing to then convert an existing office building to a primary structure was no longer the case because it was already permitted as a primary structure. That is when the initial variance case was then withdrawn and a subsequent variance was taken out, in that there was still an enclosure of that existing other primary structure which required the variance. Does that make sense?
I don't think, none of this does, but,
Right.
but I just couldn't recall why it was withdrawn and then resubmitted.
Right, the withdrawal is again because of the determination I made in, again, the original variance that, again, you did not hear was withdrawn, was for conversion of an existing accessory structure to a primary. But again, with observing land use permit number 98-165, we did not need to go down that variance road anymore in my determination because it was permitted as an other primary structure originally. So again, that request to convert isn't needed. It was already permitted as such. So that was a withdrawal of that first variance application. So they are linked. The withdrawal of the variance is linked to the decision that I had made.
Thanks. So I'll go back to my question from a moment ago. Does the board feel comfortable with what we've heard so far, making a decision whether we should hear this variance?
As the board of jurisdiction is the, because you won't get to the variance unless you.
Excuse me, yeah, whether or not we're the correct jurisdiction. Is that the right word?
Yeah.
If this is the right jurisdiction to hear this appeal. And I'll poll it and we'll just go by simple majority. Gordy, how do you feel?
I don't think they do have jurisdiction,
Okay,
given what the laws says, and they really don't have access to the property.
Terminology though, it's whether we have jurisdiction, it's whether they're an agreed
Or
party.
right, I don't think they have
Are they not?
jurisdiction to
Right.
bring a
so you don't think they're an aggrieved party? Okay, thank you. Joe?
Yeah, I don't believe they are either.
I think we have enough information. I don't think they're technically aggrieved.
Can I mull this over for just a little bit?
And from a legal standpoint, just so you know too, is that if you make a decision that they don't agree with, that they're not an agreed party, they can appeal that to the circuit court. If the circuit court changes its, says we were wrong, it comes back and you hear it anyway, if they want to do it. But that's.
Okay.
I guess that would be my other point is, you guys got to jump off when you're not talking, is I don't know if this is our job, I mean, you said we're judges. I'm not a judge.
Yeah, you are, in this situation, you are.
Yeah, in this case I am, so that's why I don't feel real comfortable with this. So it is nice to know that they could appeal this to a certain court where there is a trained judge and attorneys to hear their case. Based on what I've heard, it doesn't appear that they are aggrieved, and that's my opinion. They're really bummed out they didn't get the property, and I understand that, but that's.
And that's what your job is, to listen to what the parties, each side says, apply what they told you and make a decision. That's what your job is.
Laura, we'll skip over you for a moment. I disagree with the rest of the panel. I think that they're aggrieved and their appeal isn't because they didn't get to buy it or I believe their appeal is based on the expansion that the zoning administrator said they could do, and they disagree with that decision. And in the documentation that we were provided with, the application that we get, there's some very compelling statements in there about when this 1998 variance that had been granted, when that expired. And it appeared to me as though it had, which, and I think part or maybe all of the administrator's decision referred to this two-dwelling permit or permission. And I based on the information that I read, or at least my interpretation of that information, was that, they could appeal that zoning administrator's decision, so.
But and I don't think there's any dispute that they can appeal, but in their appeal, they have to show that they're an aggrieved party. And that's in your bylaws. And so I don't think you can get into the crux of the appeal itself. And it sounded like you were doing that, and you had an opinion one way or the other. It's whether they're an aggrieved party. It's kind of like your variances. You have to meet all three criteria. You can't approve. So if you had two, and I think we've had some where you said, God, this is a pretty good idea. They should be able to do this, but they don't meet the criteria. And you end up denying because of that. And I think you got to get by the jurisdiction question first, whether you feel one way or other about the appeal.
I don't completely disagree with what you just said, but I think that we're given an opportunity tonight to address this issue, because I feel it's going to come up again.
But they got to get through that first hurdle. And you can agree that they're an aggrieved party. I'm not saying you can't, but that's the first issue. Are you aggrieved or are you not? And I think you guys can vote on that, because it sounds like everybody kind of has enough information.
Opinion, yeah, okay. All right, thank you. Laura?
Okay, I guess I'll keep it short. I feel that they have shown enough, or have convinced me enough that they are an aggrieved party. And if that's where the decision on whether or not we have the jurisdiction to hear it, I feel that they established that they are an aggrieved party.
Okay. So, does anybody want to hear any additional testimony, or can I state it that way? Do I have to throw it back out there?
Well, unless no one's raising their hands, but I think you can ask for a motion.
Okay. Okay. All right, is there a motion to, and help me with the wording here?
The motion to determine whether we think that they're an aggrieved party and this board has jurisdiction, or not.
Okay, is there a motion to determine whether the appellants are an aggrieved party or not?
I make a motion to state that the appellants are an aggrieved party and therefore we have the jurisdiction to hear the appeal.
Okay. Is there a second to that motion? I'll second the motion. The motion has been made that the appellants are an aggrieved party and that this is the proper place to hear their appeal.
That you'd have jurisdiction to hear the appeal.
We would have jurisdiction to hear the appeal. Okay. All those in favor of the motion, as discussion on the motion?
A roll call, or you want to just?
Roll call. Okay. I'll call for a vote. Gordon, yea or nay?
No. Nay.
Joe?
Nay.
No.
Yay.
Yea. Let the record reflect that the motion was defeated by a vote of 2 in favor and 3 against. So that kills it right there,
Yeah, the board doesn't have jurisdiction to hear it then.
okay? So how do we do findings of fact?
Well, I don't think I think the findings were basically that you did determine that they weren't an agreed party, and that was, you said they were, the 3 that voted against you are saying they aren't an agreed party. And it's based on the testimony you heard, I'm sure.
Okay, okay. You got what you need, Kathy?
No, I missed what you said, I'm sorry.
I said, the findings are that the 3 nays were that the appellants were not an agreed party and thus lack standing, and the board doesn't have jurisdiction. And it was based on the testimony of all the parties that provided testimony tonight.
All right, that ends it. Any other business? Is there a motion to adjourn?
Make a motion to adjourn.
Motion by Laura, second by Joe. All those in favor, saying aye. Aye. All opposed, same sign. Motion to adjourn passes by a vote of 5-0. Thank you all for coming.